as long as something is permitted within the rules of a particular virtual space, then it's usually insulated from legal liability unless it falls into a category of a communications tort or it involves real-world commodification. If it doesn't fall into one of those two categories, generally speaking, as long as you're within the rules of the game as set up by the administrator, then basically the law really shouldn't intrude. Really part of the purpose of the EULA on the one hand and the code, that is the programming design on the other hand.
My second question went back to your article in which you talked about different approaches to regulation, one through essentially First Amendment rights, another through consumer protection, and a third through the rights of public accommodation. As you spoke about regulation as being inevitable, how do you think it's going to come about, and will there be different theoretical approaches for different kinds of virtual worlds? You also make a distinction between a virtual world that involves commodification and small ones that prohibit it, or those that are educational and therapeutic. Go ahead.
You won't be surprised to learn that most of the regulation will first come out of property issues, because in fact, when you think about how states form in the real world, it's often property that gets people to form particular kinds of organizations and particular kinds of regulations. And so consumer protection is going to be the first model that'll probably be involved in regulation. To the extent that the world holds itself out as allowing people to have property or things like property, over time what you'll get is interest. You'll get contract lawsuits, you'll get property lawsuits. Those things will come first.